Good morning, everyone. In Introduction to Law, I thought I would tackle Chapter 9 today, and that's tort law. It's a huge chapter, a lot of information in it. It's an important chapter for those of you that want to, well, either be an attorney or paralegal, legal assistant, secretary, because it's a vast area of law where there's significant employment opportunities because it's very intensive with regard to the gathering of information, which paralegals, legal assistants, and attorneys all have to have skills and abilities to perform. And paralegals can be utilized significantly through the process of gathering information from the other party, like interrogatories and requests for production of documents, or producing requests for depositions to bring witnesses in to be examined under oath, or just gathering of other information like police reports and insurance policies. It's very information intensive, for lack of a better way of saying it. And the team, if you will, attorneys, paralegals, legal assistants, and secretaries can play a critical role in gathering all this information. Tort law is very, very significant because there's a significant amount of money involved, not only for the people suing, the plaintiffs, but also for the defendants, often insurance companies, but also individuals and companies themselves that may not have insurance for the type of claim being brought. It just makes up a huge, significant part of our litigation process. In fact, it's even in political realms from time to time, depending on what's important. If the economy is obviously in dire straits, or if we're at a time of COVID crisis or whatever it is, our political attentions are spent on that. But there's been cyclical periods of time where we talk about tort reform because of the nature of the vast, massive amount of litigation that goes on in our nation's courtrooms over litigating tort claims. So what are torts? Let's start with that. Torts are basically private wrongs and related to private duties we owe one another. It's civil in nature. Sometimes it overlaps with criminal law if it's an intentional tort. I'll get to that in a minute. But generally, torts are these private wrongs that allow us to seek redress, usually money, from the party that's harmed us. And everything really, when you think about it, it's civil outside the realm of family law, contract law, and business contractual processes in real estate. But think of it as the biggest ball of wax, if you will, in the tort realm is negligence. But before I get into the negligence field, I do want to talk about intentional torts. They don't make up a significant part of the litigation we do because they often overlap with criminal behavior. And the book gives you a few examples of some of the intentional torts that exist, like false imprisonment. Well, kidnapping is usually got the same elements as false imprisonments. The criminal courts will often take care of any injury financially to a victim in that realm. It also makes up the charge of assault and battery is also a civil tort. You can sue for damages for being assaulted or battered or a combination of both. The difference, some people like to know, assault's being put in apprehension of being offensively touched or hit, and the battery is the offensive touching. They can be mutually exclusive. So you take a swing at me, I see it coming, I duck, you miss. There's never been any contact. So there's no battery, but there is an assault because I felt apprehension of the offensive touching. A battery can happen without an assault as well. If you were to come up behind me, wasn't aware you were there, and you punched me in the back of the head, that's a battery, but no assault because I wasn't aware and didn't feel apprehension of the coming blow. They're not huge in the civil realm because insurance doesn't cover intentional torts usually. People that are usually involved in intentional torts like assaults and batteries and false imprisonment and things of that nature often don't have deep pockets or financial resources to pay the victim of for further financial losses that occur in these kinds of cases. So they're not often pursued except through the criminal realm. You can get restitution in a criminal case. So oftentimes the criminal justice system helps compensate victims of intentional torts. There's some others like fraud that might be both a crime and an intentional tort, because fraud is usually not passive, it's active, meaning overtly lying to another person to induce them to enter into some kind of contract or loss of resources in some way. It's a very broad definition of fraud, but it's also an intentional tort, and that can sometimes be significantly sued in the civil realm as well. I don't want to make it sound like intentional torts are never part of the tort realm in the civil courts. It's just not nearly as significant as the traditional torts of negligence and product liability, which we'll go into now. The different terminology, well, starting off with negligence, it requires 4 elements. The first is a duty. We all owe duties to one another to behave in a certain fashion. No one's in my office right now. It's just me swiveling around in my chair. There's an expectation I behave in a certain way, not to put risk into property, damaging my own property or other people's property, although I couldn't really sue myself, could I? But say I had this office was shared with other people and I'm swinging around kind of inappropriately in my chair and I cause damage to other people's property or to their persons because maybe somebody's, and I'm aware that they're near me and I'm swinging around, I owe a duty to act reasonably. And that's a totality of factors. It's very contextual. So my duty of care in sitting in this chair and swiveling about is different if I know there's other people's property located adjacent to me, or whether there's people standing or sitting very close to me. My duty of care changes based upon the context that I'm in. So we all owe duties of care. So that's the first element. What that duty of care is based upon context. And the term we usually use is foreseeable. What are the foreseeable consequences of behaving in a certain fashion under the circumstances? We're not obliged to act as superhuman beings and be perfect at all junctures. We're expected to act as the reasonable, prudent person would in that situation, in that context. So that's the first element to prove negligence, that you owed a duty of care. The second one that's implicit is you breached that duty. You failed to act as a reasonable, prudent person would in that circumstance. The third element, and I go out of the order of most authors and lecturers and books, is that there needs to be damage. Don't worry, we're going to go over all 4 elements. That's consistent through all modes of instruction, but I like to go right to the next one. So there's a duty, there's a breach of the duty, and there's some injury or loss. The property, you were driving recklessly in your car or inappropriately, negligently. You weren't careful. You were trying to change your radio station or look at a text real quick on your phone, and you inadvertently drifted to the side and you hit a parked car. The parked car now has damage to its bumper and its rear door and quarter panel. That's the damage, what it would cost to repair that car and put it in a position it would have been in but for your negligent act. That's the third element. The fourth element sometimes seems obvious, and that's called both legal and factual causation. Well, factual causation means is but for what your negligent act was, that car wouldn't have that damage to it. That part is easy, and it's often overlapping fairly significant with legal cause. But with legal cause means the loss or injury has to be foreseeable in relation to the nature of the negligent act you did. Sometimes you did a really minor negligent act, but it creates a ripple effect. So if I was negligent in the classroom and you said, "Hey, Corman, you got an extra pencil or pen?" And I'm like, "Sure," just out of a careless moment, I kind of flick it over to you. And because I threw it a little too fast, a little too high, and a little too unexpectedly, unreasonably, it strikes you in the eye. And it's, oh, geez, hit you. Your eye was open, it hit you, you get a scratched cornea, and you're concerned, and so you go down to the nurse's station. The nurse says, "Geez, that looks like we might have to have it looked at by an optometrist, an eye doctor over at Haywood Hospital." And then while shipping you over to Haywood Hospital in a cruiser or an ambulance, there's a slick spot in the road due to an icy condition, and the ambulance goes off the road, and it rolls over and catches on fire, and you're burned over 90% of your body. Am I the factual cause of putting you in that position where you are now burned over 90% of your body by throwing you a pencil or pen negligently? Well, yeah, that's the factual cause. But is it so far removed from foreseeability that me throwing a pencil or pen at you negligently would lead to you being engulfed in flames as a result of a car accident via the ambulance trip to the hospital shortly thereafter? It's probably a bit of a far-fetched scenario, and that's kind of the cutoff, if you will. I don't always know what it is. People argue about it all the time. There's trials just over that question of proximate cause. How foreseeable was the negligent behavior linked to the loss, or is it so remote, so speculative, so far removed and unpredictable that we don't want to hold people accountable because the chain is too far from the source? There's a famous case called Fallsgraf. I didn't see it in your book. It might be, but the chapter is so lengthy. The Fallsgraf case is a famous case back in the turn of the in the 18th and the 19th century, or from the 19th to the 20th century. There was a bunch of people on a train trestle that was on sort of a floating platform. It had some shake to it, if you will, for lack of a better way of saying it. And people were getting in and out of the train, but these train conductors and train workers were pushing people in and out of the train rapidly to keep the time going. It was arguably a negligent act. Well, one of the people that was pushed by one of the train conductors pushed this gentleman in a negligent fashion to get him on the train quickly. He drops a suitcase. In the suitcase is located either some fireworks or explosives, and they explode. And when they explode, it creates a concussion, like a very loud and violent reverberation through that platform, and the platform shakes. And when it shakes, a very large scale that was used for weighing, I guess, products that came off the train, I don't know if it was grain or whatever, but this very large scale falls over and lands on an individual's head, causing significant skull injuries, brain injuries, I believe, actually. And the question was, should the railway and the train conductor be liable for a brain injury as a result of probably negligently ushering someone onto a train? Would that be a foreseeable consequence that an explosion might occur in these remotely located scales behind the passenger section of the train would fall over as a result of that? It was a bit speculative, and a famous judge called Cardozo, and there's a Cardozo Law School now named after Justice Cardozo, reasoned that there has to be a cutoff point for society to be able to foresee when they're going to be liable for their negligent behavior. So all four elements have to be there: duty, breach of duty, some kind of damage, personal injury, property damage. You have to have some loss. Have you ever been in a minor car accident where cars make contact? You stop and you get out of the car and you look and you can see no scratches, no dents, no damage. Was there a negligent act? Yeah, there was a failing to act reasonably under the circumstance because the person took their eye off the road or failed to yield in traffic. And it's their fault, but the problem is there's no damage, so there's no negligence. You have to have damage, you have to have loss. I think what if a surgeon makes a mistake in the technique they're doing on your you're not going to have your kidney removed, I hope, your appendix removed, and they do something negligent in the way in which they perform the surgery. I'm just reaching for my coffee. But you don't get an infection. The appendix is ultimately removed appropriately. There's no additional size and scarring or in your recovery period, but they did it in let's say, a technique that was recognized as not appropriate, and therefore it's per se negligence because they're not using modern surgical practices in the removing of the appendix. But if you haven't been harmed, you have no case. You have to have that last element, which seems obvious to most people. Foreseeability is that contextual component to it. Everything has to be related to foreseeables. I always think of the driving example. If I'm driving out in Oklahoma where I can see to the left of me, meaning off the road, I can see basically pure dust bowl, pure, prairie land for miles to the left side of me, miles to the right side of me. I can see basically to the curvature of the earth out into the front of me. There's no traffic. I look in my rear mirror and I can see miles behind me. There's no traffic. Is my duty of driving care different than if I were driving in New York City in Times Square and stop and go traffic with bicyclists and pedestrians coming and crossing and going? Would my degree of care be expected to be different based upon those foreseeable circumstances you're in? And the answer is yes, of course. It's just like shooting a gun. If I go out into an open field where there's a large earth berm and I own the property and it's fenced off and it's posted, I look around the property, I see no people anywhere in the area, and I'm going to shoot in the direction where it's going to go into this hill, for lack of a better way of saying it. Is that different than if I were to go shooting and I just decide to shoot in some open brush where I know people often walk and do bird watching and picnic just on the other side of the open brush? Yes, the duty of care is very different based upon the foreseeable consequences that can happen in those circumstances. And then they give different terms. The next one is like intentional tort. I talk about strict liability. Strict liability is an important concept. It sometimes, I think, fools people to think it's It's a great type of lawsuit. Well, it is a great type of lawsuit, but you still have to prove something very significant. Why it's great is because the plaintiff doesn't have to prove that the defendant was negligent, simply that they were engaging in an inherently dangerous conduct at the time. So I always use the example of someone who does blasting for a highway. They're a private company, they're fully licensed, and they go out and blast ledge, so some new roadway or an expanded bridge can be placed there. Let's assume they've done everything that a reasonable blaster, explosive expert would do. They put down all those rubber carpet, absorbent, I don't know what they're called exactly, but buffers. So when the explosion goes off, it captures all the debris. They use the right amount of explosive based upon mathematical tests. They use all the expertise and reasonableness they know. They warn all the neighborhood communities. They put up every possible safety mechanism they can known in the industry for blasting. They blast, they do it all within the industry standards that's expected, and a large rock manages to escape the containment area. It flies through the air, lands a half-mile away, and it goes through my windshield of my car. Are they liable? Yes, but they're not liable for negligence because negligence requires them to be what? Failing to act as a reasonable, prudent person would when doing explosion. Were they acting reasonable? Let's argue that they were acting even beyond reasonable. They were acting exceptionally safe. But because they were engaged in what we consider to be an inherently dangerous type of behavior, they will be strictly liable. They're still liable no matter how well they try to prevent that injury. That's also true of like drug manufacturers, for example. When drug manufacturers manufacture a drug, they go through all kinds of testing, let's hope. Let's hope they're a moral and ethical pharmaceutical company. They produce the drug with all kinds of safety protocols. They do all kinds of testing on volunteers first and animals, and laboratory analysis goes on. They work with the FDA to make sure the drug is not only effective, it works, helps whatever ailment that people have related to the drug's production, but it also meets all the standards of the government. And everyone says not only does it work, it's safe. The government thinks it's safe. We've run it for 2 years. We've had no ill effects on any of the people that have voluntarily tried to use it. We know of no known side effects. Well, now we produce it. It's an arthritis drug. And we get it out there. And after a couple of years, we find that people using our drug, it causes blindness or it causes a heart ailment. You know, the aorta in your heart deteriorates as a result of and you can prove it's connected to taking that medication. Now, can you sue them for negligence? Well, you can, but you're going to have a hard time proving negligence because did they act improvidently? Did they act unreasonably? Well, they actually acted exceptionally well. They worked cooperatively with the FDA. They didn't try to hide anything. There was no fraud involved. They acted reasonably. There's no negligence here. But are they liable? Yes, because of the concept of strict liability. Manufacturing drugs for human consumption is an inherently dangerous activity. So once you, but that's hard to prove sometimes, but drug manufacturing is not hard to prove. Being an explosive, company that explodes ledge and rock and granite and things like that, that's an inherently dangerous behavior. Once you can establish that someone's or a company's behaving in an inherently dangerous industry or production, you just have to prove damages afterwards. That's why it's popular, because if you can prove inherently dangerous behavior and then some kind of damage to a party, you win the case. You don't have to prove carelessness. Helps if you can, because I think that's compelling to a jury or a fact finder, but it's not required. So negligence concept, yeah, it does list them all. 4 nice. I wanted to give you a couple of examples here. Range of possible injury. There can be property damage. There can be damage to your ability to earn income. By the way, one of the things we don't do too much in Massachusetts, okay, there are some, and people always want to point out the exceptions after I put up a lecture like this or talk in class about it, is that we rarely want to grant punitive damages. That's like a windfall for the plaintiff. So we usually want to compensate for actual loss. You're not entitled to win the lottery from being injured in a personal injury accident or a medical malpractice case or someone doing something negligently causing damage to your property. You should be made whole, which means put in a position you would have been in but for the other party's negligence. So let's assume I got in a very serious car accident. You were careless, you were texting while you were driving, and I can prove all that, for example. Maybe you admit it, and you hit me. If I just have damage to my car, it's pretty easy to measure those actual damages. It costs $1,500 to get the bodywork repaired on my car. Straightforward. Maybe there's a little bit of what we call related damages, ancillary damages, consequential damages. You'd be liable for those too in Massachusetts. Like I needed a rental car for a week. Things like that. Maybe I missed a day of work, and the kind of job I have, I got docked a day's pay. You'd be responsible for that. That's consequential, and it's also what? It's foreseeable. What you're not entitled to is usually punitive damages. That's where we want to make the defendant pay additional monies to deter that kind of behavior in the future. That does apply in some cases, especially if it's a corporation or a very, very wealthy defendant, because we need to motivate them not to do that kind of contact again. But Massachusetts doesn't favor punitive damages. You should know about them. But generally speaking, if we're in a law firm and we're either suing on behalf of people who have been injured either in their persons or in their property from somebody else's negligence or dangerous behavior, we're probably going to only be seeking monies to make them whole. We're not going to be seeking punitive damages. What does often get perceived as punitive damages is things like pain and suffering. So I got in that car accident with you. You got $1,500 of damage to my car, but I break both my legs. Now, you pay my medical bills as well. That's a consequence of your negligence. That's direct and reasonable and foreseeable. But what about the fact that my legs, I might need surgery on my legs. I won't be able to participate in my square dancing festivities that I love to do, in the polka I like to do during the annual fairs that come to town. I can't go bowling with my kids, which is actually a favor if you ask me. But I can't do the usual things I do, and I am in pain. I'm suffering from pain and suffering, and I've lost my use and enjoyment of my legs to do the activities I used to do. I might lose work, but the pain and suffering is the one that often is viewed by people as punitive damages. It's not, but it's hard to calculate. What is it worth to somebody who's lost their ability to maybe walk and jog or do activities they did previously, maybe for a closed window for 6 months, a year, but maybe permanently? Maybe you won't be able to do some of the things you used to do ever again. What is that worth? And it's up to the fact finder. It's up to if it's a judge trial, it's up to the judge. If it's a jury trial, it's up to the jury to determine what is the pain and suffering. What kind, and all we can give is money. People say, well, all the route is for money. Well, what else can you give the person? You can't give them their legs back or their ability to walk without pain back, potentially. You hope that they recover 100%. But if they don't, it's up to the jury to compensate them for that loss of function, that loss of enjoyment, that pain that they were in, maybe temporarily. And sometimes it can be permanent. Depends on the nature of the injury received. And that's why sometimes judgments come in very, very large. Those are the ones you read about. Most judgments, especially in Worcester County, seem to be very modest when it comes to pain and suffering judgment. Juries tend to really like to pay. Your car was damaged for $1,500. You lost 3 days from work. You had to have a rental car for 2 days. That's all you're getting. They don't like to give money, jurors, very often for pain and suffering, unless it's really what I consider to be a blatantly heinous injury, like a loss of a limb, or a very objective injury that does limit your ability to do things you used to do, and the testimony is credible that you are going to be suffering from pain and limitations for a significant more lengthy period of time in your life, or you may have major scarring or something like that. Then it'd be worth potentially great more, but that's not punitive. Proving proximate. Less reps ipsa loquitur. Let the matter stand. The reason why I laugh is I always think I'm going to have a boat someday, and you're supposed to name a boat. One of the names of the boat I always thought would be cool. The res ipsa loquitur. Res ipsa loquitur is roughly translated into the matter speaks for itself. It's still a negligence claim, but you don't have to prove that the party failed to do something they were supposed to do or did something inappropriately as a reasonable, prudent person wouldn't have done. You basically say that the consequences speak for themselves. It's obviously because of negligence. I always use an elevator example. So let's assume that the company you go to, you get in the elevator, you're on the 7th floor, hit one, you want to go down, and the thing just collapses right down to the first floor. You suffer very serious injuries to your legs, your back, your arm, head injury, who knows, all kinds of serious problems happen. You sue based upon negligence. Well, what if the company that you went to can prove that they maintain their elevator twice as often as required under the standards for inspections of elevators? You always have it inspected. You always have it maintained. They do everything the right way. Are you going to have a tough time proving negligence in the traditional sense? Yeah, because they maintained it. Let's assume it's a fairly modern elevator. They've had the elevator company come twice as often as supposed to check on it and put whatever parts are in there to make sure it has integrity and it functions appropriately and safely. But yet this still happened. Well, why did it happen? Because somebody dropped the ball somewhere in some way, and res ipsa loquitur is what you'd use. Like kind of like, say, going for surgery. I'm using myself going to surgery. I'm going to have my I keep going to my kidney for some reason, but my appendix taken out. I don't know what happens. I'm put under for the surgery. I wake up and I don't feel great, but I don't feel great a week or two later. And finally go back and somebody does some kind of PET scan, a CAT scan, and they say, geez, there's a foreign object in the area where your appendix used to be. And they open me up and they find a junior mint. Well, I probably would have dissolved. Maybe there's a Seinfeld fan on here. But they find a sponge, a surgical sponge there. I can't prove which doctor or nurse left it there, but by the very fact it's found there, it proves somebody failed to do what a reasonable nurse and doctor would do during the course of a surgery. Res ipsa loquitur. The matter speaks for itself. I think the famous case that came out of that was somebody was walking down the street in either Chicago or New York, and a big ream of, I believe, paper fell out of like the 11th story of the building, landed on the plaintiff's head, and caused very, very severe injuries to the person. Through the investigation, they couldn't prove how or why that happened, but obviously the party that had dominion and control of the 11th floor, somebody or their staff, was negligent or intentional. Things just don't fall out of the 11th story that are big and heavy and bulky unless somebody did something inappropriately. Res ipsa loquitur. It's a tool in law. Boy, this chapter is huge. Strict liability, already went over that. Again, strict liability is not as easy as sound. You still have to prove they're engaged in inherently dangerous activity. A lot of case law in the book. I think it does a nice job. It gives you some good examples of the application of these rules. Oh, then the intentional tort that I didn't talk about, which could come up, I think, a fair amount in traditional civil litigation, is libel and slander. One is written, one is spoken. It's just got to be told to a third party, which is called publication. It doesn't have to be in a newspaper or magazine. I hear the word publication, you often think that. But people do sue over false statements made by somebody else, and it has to be false. It has to be a factual claim. You can't just say, this person's a jerk, this person's incompetent, this person's a fool. That is protected because it's an opinion. But if you say, Joe Smith is a convicted bank robber, and Joe Smith is not, and as a result of the statements made by Joe Smith to a third party, they lose reputation in the community or work or economic standing, that's a great case for defamation or libel and slander. That's what the current or fairly recent case of, I think his name is Alex Jones, something called InfoWars. He supposedly came out and said the parents and the families of people who lost children in the Newtown massacre were lying, that they were actors, they didn't lose their kids, and it was all a big anti-gun facade to curb gun rights. He just fairly recently was given judgments of almost $1 billion against him because it cast those people in a falsehood of factual scenario that other people believed, and it damaged their reputation in the community, and it harmed them emotionally. Got to be careful on libel and slander. Private individuals, all you have to prove is the other party was negligent in providing false factual information to a third party. If the person's a public figure in the community, you're a congressperson, you're the president of the United States, you're a senator, you're an actor, an actress, and there's like a whole analysis that goes into whether or not you're a public figure or not. We want people to be openly able to discuss, even if mistaken, the beliefs and ideas about especially politicians. So in order to a politician to sue because somebody published a factual falsehood about them, not an opinion, a factual falsehood, that victim would have to be able to prove actual malice, that the publisher knew the information was in fact fallacious falsehood, not just that they were careless. So if I say, geez, I think, let's say some future president, um, President Smith, clearly benefited from this act he did to financially reward his family. And it turns out to be completely false. But I heard it through somebody else and I believed it was true. Well, then I can't be sued. I can be sued, but I will win the lawsuit because that public figure, the President of the United States, can have speeches made about him, even though false, as long as there can't be proven that they were intentionally known to be false. It's a very difficult standard to prove actual malice. And the reason why we have the standard in the United States is we want people to be able to exchange information without a chilling effect upon public officials and public figures. People argue about that. Donald Trump argued about that many times, that he should be able to sue when people said things about him all the time because he felt like the standard was too onerous, too difficult, and therefore people would say, falsehoods about him all the time, and he wouldn't have any real redress. Many politicians, not just Trump, but on either side of the spectrum politically, have often lamented over their ability to be kind of muckraked through the press and tabloids and on the internet when the information is in fact false, and there's no legal redress for it. Well, there is, but you have to prove actual malice, a knowing factual lie, not opinion, fact. I went over assault and battery, fraud, trespass. Trespass is just that. But there is an element that's required. The person has to, like if I don't have my property marked, and I don't, and you were walking across my property, you're not committing trespass. You only commit trespass when I give you notice that you're not allowed onto my property, either by posting the property or giving you direct notice. It's a criminal charge. It's also intentional. You have to intentionally do it. So this is one of the intentional torts. In the criminal realm, sometimes a person will be picked up and the police will think that maybe they're involved in drug activity, so they'll use the pretext of trespassing. But they'll be in an area where it's not marked to stay away, and in fact they were invited there by a person that lives in the apartment complex or something like that, so they're not trespassing at all. And how landlords and landowners protect themselves is by posting their property conspicuously, and or if they know people that they don't like shouldn't be around, they give them written notice and prove that the defendant was served with a no trespass order. Not a big deal. Emotional distress. Be careful on emotional distress. Usually most jurisdictions, because let's face it, people do and say things all the time that hurt our feelings. Should we be able to sue for that? Someone can say yes. Well, we need to create a higher standard or we're going to be more even sue crazy than we already are. And so in most jurisdictions, to sue for emotional distress, the defendant, the party being sued, had to have committed usually an outrageous act or statement that was designed to hurt the victim emotionally, that it was reasonable to expect that emotional harm would occur, and that emotional harm does actually occur, and it needs to be proven. So sometimes someone will say, well, this person did this act, and it was clearly outrageous, and it hurt me emotionally, and that's what they were hoping to do. They have to intend it. How do you prove somebody's intent? Very, very challenging. And the other thing is they say, well, now I was emotionally harmed. And then if I was representing the defendant, I'd say, well, where's the harm? Did you lose time from work? Did you gain or lose significant weight because of this? And you can correlate it to that action of the defendant. Are you seeing a counselor as a result? Are you on medications to help you sleep as a result? And if the plaintiff can't prove a change in circumstances from the outrageous behavior of the party, very, very difficult to succeed on emotional distress claims. Otherwise, it would open up a whole can of litigate, really wild. Product liability relates a little bit to strict liability. Why it's often dealt with in a different realm is if you can prove a product is inherently dangerous from its design or manufacture and is causing injury, usually it creates a class action. You get multiple litigants going in there. And sometimes the reward for per individual might be very small, but in the whole class, there might be a very huge pool of money. And the attorneys often take 30 to 40% of that as a contingency fee basis. So product liability often overlaps with strict liability. It helps if it breaches a warranty, then a warranty will, something like this product will function safely and appropriately if used under these conditions. And it doesn't, you get the right to get the product replaced and or get your money back for the product. But I'm thinking beyond that the product has caused you injury. The blender explodes and shards of glass go everywhere because they made the glass out of some non-tempered glass and it's relatively fragile in the volume of pressure and action that goes on in a blender should reasonably expect people to be harmed. That will open up a product liability case. But it still applies many of the same standards from the other things we discussed previously. Now, some of the defenses, statute of limitations is a big one. I'm not going to certainly test you on this, but in most states, they have a limitation. You have to take action within a reasonable period of time or you lose your right to sue, basically. For most tort claims in Massachusetts, it's 3 years. So I get into a car accident with you, I hurt my back, I start doing some treatment with a chiropractor. If I don't take a lawsuit from 3 years of the date of the wrong, the date of the negligence, the date of the tort, I lose that. And there's no like window of tolling except if you're a minor. If you're a minor, the statute of limitation doesn't begin to run until you're 18. So if you're injured when you're 7, you have all this extra time. But generally speaking, an adult, for most torts, there are special statutory exceptions for certain kinds of claims where notice has to be much sooner. If it's against the government, it has to be given very rapidly. And if it's for certain kinds of claims, you might have different windows. And I don't know them all. You just need to know there's something called the statute of limitation. I used to do a fair amount of tort law at one time, and the acronym for statute of limitation is SOL, and it means just that you would put that, we'd write that on the outside of the files in big red letters, SOL with the date, because if you don't file suit within the statute of limitation, there's almost no recourse. It's one of the strictest standards there are in law. You just can't sue because we don't want people bringing out stale claims because it's not necessarily fair to anybody. Where are the witnesses now? Where's the evidence? After 3 years, it might be hard to track down. Oh, geez, I had my car sitting in the yard with all the damage on it. It's gone now, or I had photographs of that. It's on my old phone that I traded in. And is it on the cloud somewhere? How do I find that? And so it's only fundamentally fair that we have statute of limitations for most torts. That's one big defense. And then there's others, employer, employee. Employer and employee, there isn't necessarily a defense, but employees that are hurt during the course and scope of their employment, in Massachusetts at least, can't sue for torts of their employer. All they can sue for is something called workers' compensation, and employers have to maintain policies of insurance. If they don't, that's considered a tort in and of itself for failing to keep workers' compensation insurance. But all the employee is entitled to is lost wages, money for loss of function, and their medical bills to be paid for. They kind of create a special caste of tort law when it comes to employer-employee relationships. And the good news, I guess the good news for the employer, it does reduce risk of loss because it's only for lost wages, and for loss of function and medical bills it can be significant. But most employers carry workers' compensation insurance. The good news for employees is there's no defense for the employee being negligent when they did that. Like, I'm being careless when I'm moving, I'm carrying way too much stuff at once. Obviously, it's awkward, it's inappropriate. I'm being negligent. And while I'm carrying all these boxes down to the next floor, I trip, I fall down, I break my leg. Am I eligible for workers' compensation benefits while I'm out of work? Yes, I am, even though I was negligent. As long as I wasn't intentionally trying to harm myself or I wasn't doing an act designed to injure the employer's business, I'd be eligible for it. And the employer, the vicarious liability is a term sometimes called respondent superior. They're mostly synonymous. Employers are liable through vicarious liability for the conduct of their employees as long as the employee's behavior was in the course and scope of the employment. Now, if I'm at work at the Mount, for example, I'm working up at the Mount and I'm working, 8 to 4 that day, and I need to get some copies made for my students, and I decide to go over to Staples because it's quicker. And while I'm driving over, I commit a negligent act. There might be an argument there that the Mount Wachusett Community College should be responsible because I was doing it for the advancement of my employer-employee relationship. So sometimes people say, well, geez, some employee beat somebody up. Client that was in I always go back to a 7-Eleven case that I had some involvement in. There was a clerk at a 7-Eleven had some young kids that were hanging around, skateboarders type kids, and they were kind of scaring away customers basically because they were hanging around outside the store. They were hanging around inside the store, and they were loud and and they were young and they kept out traditional business. So the clerk kept trying to kick everybody out. They kept refusing to leave. The one day the clerk kind of snapped and physically removed one of the people. And when he did, he kind of pushed him down and he tripped over one of those parking berms. And the person who was pushed got some pretty significant injuries. Well, the clerk doesn't have a lot of money, so who did we sue? 7-Eleven. And when you sue 7-Eleven, 7-Eleven's defense is, we didn't authorize our employee to touch anybody. In fact, it's an overt policy that the employees have to agree never to use physical force against anybody whatsoever under any circumstances. They need to do that. They need to call the police. But would they still be liable is the question, even though the policy is contrary to what the employee did? Yes, they would, because the employee wasn't trying to do something that was purely self-serving to him or her. The employee was trying to advance, although wrongfully, the interests of the employer. And that's what we call respondent superior. It comes out, it's broader than vicarious liability. Well, actually, respondent superiority is narrower. That's an employment relationship. But vicarious liability, sometimes we're liable for other people's torts. There's a controversial issue whether parents are liable for their children's torts. Generally, no. I would argue, other people argue against that all the time. So, well, yes, they are. I think it still has to be foreseeable that the parent had some foreseeability that the young person was going to commit some kind of tortious act. But if my kid's driving my car, that's negligent entrustment, so there might be an action there. But generally speaking, my kid goes out and does some kind of act. If it wasn't foreseen to me and I didn't know it, I'm not going to bear responsibility entirely for that, or maybe at all, for my children's conduct. Medical malpractice. I don't want to get too deep into that, but medical malpractice is just as a sound. Some professional in the medical field, just like lawyers, fail to do what a reasonable, skilled, knowledgeable physician, attorney, accountant, psychiatrist would have done in the same circumstance. And the plaintiff has been harmed as a result. What if I commit malpractice as an attorney and do a really crappy job for my client? Say it's a criminal case and my client gets found not guilty. Well, there's not malpractice there. It might be malpractice behavior, but it's not a malpractice case because my client hasn't been harmed. Same with medical. The doctor does everything backwards and wrong and inappropriately, doesn't wash his hands and doesn't sterilize the instrument. But the plaintiff doesn't get any infection, get any harm, and the resulting surgery solves the plaintiff's problems. There's no malpractice case. Now, some of the here goes. Where are the defenses? Contributory and comparative negligence. You should know the difference, even though nowadays almost every state in the union does comparative negligence. But contributory negligence is, what if the plaintiff can argue, or the defendant says, yeah, I was careless when I was driving on the road, but the defendant was also speeding at the time I crossed the yellow lines, and their speeding contributed to the outcome of the harm. Well, in those states that still honor contributory negligence, if the plaintiff is at all at fault for the injuries, loss, property damage that occurred, they're barred from any kind of recovery. It's an absolute defense. And that's why you can see why most states don't do it. Most states do comparative negligence. What comparative negligence is if the plaintiff, the party suing, is 50% or greater at fault for the loss, the event, if you will, then they're barred from any recovery. But if they're proportionally less responsible than the defendant, under 50%, 40%, 30%, their judgment will simply be reduced by their proportional share of responsibility up to 50%. If it's over 50%, the plaintiff can't prevail. But if their own comparative negligence is 25% and the jury thinks the damages are $100,000, they'll now be awarded $75,000. And that's most jurisdictions. And that comes up a lot in cases where the defendant will argue the plaintiff had some responsibility for the outcome. Hopefully you can get it over 50% so you don't lose anything because they're barred from a claim then. But if you can produce any degree of fault that the jury believes, or the judge, if it's a judge trial, there will be a reduction in the award for the plaintiff. Assumption of the risk is a classic one. This happens a lot where somebody's engaging in an activity that they could foresee themselves the inherent danger of what they're doing. So if we're going out water skiing today and you're watching everybody going out in the skis and people are flipping over the waves and they're kind of violently being thrown into the water and they're landing really hard, and then you decide to go skiing and you watch this whole scenario and you see people falling violently and things like that, and you go out skiing and you fall, which is foreseeable because you've seen so many other people fall, and you crash kind of hard, and say you tear your rotator cuff on your shoulder during the fall. Now you want to sue the plaintiff for negligence. Their defense might be you assume the risk. Sometimes we overtly assume the risk by acknowledging it by signing a waiver. So you want to ride on that mechanical bull, they often make you sign a waiver because you're assuming certain risks by riding on the mechanical bull, being thrown in the air, and although landing on padded areas, there's still a chance you could get hurt during the process. You're going skydiving. Is there certain inherent risks that you should be aware of? Yes, but if I'm the provider of the services, it'd be nice if you signed a waiver. Now, waivers aren't pure protection for the other side. It does generally protect you from general negligence, but it won't protect you from gross negligence or the wanton disregard for people's safety, because as a society, we don't want people to be able to write off their rights for someone being really inappropriate in their behavior, like gross negligence or reckless disregard or intentional conduct. Waivers don't work for those. But even if you don't have a waiver, sometimes people are engaging in inherently dangerous conduct. I always think of this thing I was involved in as a criminal defense attorney, not civilly, but a group of kids were doing, they're calling it car rodeo or something like that. The kids would ride on the hood of the car, and the driver of the car would do donuts in a snow covered parking lot that was vacant and open, and they'd spin around and the kids would try to hold on to the hood, and these young people were getting flicked off of it, and no one was really getting injured. Well, one kid finally does get injured, and the question is now the kid has a broken leg, he got thrown off the hood. Was the driver of the car acting negligently? I think that's fairly obvious. You don't drive with people on your vehicle spinning and doing donuts around in a circle. That is negligent behavior per se, or maybe strict liability, right? But at the same time, the young person that was riding on the hood kind of knew what they were getting into. That's a kind of a great thumbnail sketch of the argument we make for assumption of the risk. Last clear chance doesn't come up too much, but you should know about it. Like, I hit you on the sidewalk while you're walking with my car. Seems pretty straightforward, right? But what if you saw me driving erratically all the way down Green Street? You're up near Haywood Hospital. I'm coming up from the mount, and you see my car kind of bouncing off both sides of the curb back and forth, and I'm edging my way up at a moderate, 20 miles an hour, and you got plenty of time to step away and climb up the stairs up to Haywood Hospital. But instead, what do? You stay standing at the edge of the crosswalk, watching me drive like a fool all the way up the road. There's an argument there that you, one, assume the risk, but the second argument is you had the last clear chance to basically avoid my negligence. It's kind of like seeing somebody barreling down the road, and you see them maybe a quarter mile down the road, and you see they're entering into your lane and going back into their lane. What should you do is the argument is you have an affirmative duty as a last clear chance to maybe pull over into a parking lot or pull over into the emergency breakdown lane to avoid the defendant's negligence. It's not a very popular defense, but it does come up from time to time. Ethical considerations, chapter summary. I'm trying to see if there's anything I missed. Chapter's really well written. It's just very, very long. I went for an hour, almost an hour, way too long. But do ask any questions you have. And why I say this comes up politically, I think it was when George Bush, the younger, was running for president. He was out on the campaign trail. He was pushing for tort reform, that the reason why people are getting out of medical fields and other fields is because of the exorbitant cost of medical liability insurance. It was too much, and people were avoiding entering into certain fields within medicine because they were inherently dangerous for being sued, like OBGYN and obstetricians, like, helping to live births of babies. It can be rife with claims of malpractice. So it is in our political lexicon to worry about tort reform. But I argue on the other side that if it wasn't for torts, manufacturers would continue to make very, very poorly designed, unsafe products. And maybe physicians, doctors, lawyers, drivers of motor vehicles, all of us wouldn't behave in a safer fashion as a result of our concerns for potentially being sued. So it goes motivation any other way. But, we tend to only hear about the sensational cases where a woman spills a cup of coffee on her lap as a result of getting it from McDonald's and she receives an exorbitant judgment from the jury. And people say that should not be allowed. And then tort reform kind of kicks back in. What people don't know about that case often is that McDonald's was warned over and over again at that franchise locations that they were serving their coffee at roughly 205, almost boiling, 205 degrees, because they get more product out of the beans by brewing it in that fashion. And they were warned over and over again that people were getting burned to lower the temperature of the serving degrees when it comes out to the customer. And they ignored that to make more profit. And the person, when they got burned, had to have skin grafts and everything else. So it was a fairly serious case. But I get the argument. It's like sometimes we are a sue happy nation, and people often create a chilling effect on society and businesses if they're always fearful about being sued. I think the good news is most jurors are reasonable, and it's the reasonable, prudent person standard. And I think jurors often come back, and judges too, with a recognition of when did somebody really fail to do what needed to be done in the tort realm. Otherwise, the chapter's great. Don't be afraid to ask questions. It's a well-written chapter. It's very lengthy. Break it down into parts. And again, don't ever be afraid to reach out and ask questions. And I'm hopefully always available to get back to you within 24 hours if you have any questions or concerns. Otherwise, be well. Oh, and tort law is often in the legal studies curriculum. I don't know what semesters it's offered, but I know the numbers of students who have been asking for it have increased fairly recently. Depends on when you look at this video, but keep an eye on that if you like this kind of stuff. And there is an area of work definitely to be done both for attorneys and for paralegals and legal assistants. There's a lot of process involved in litigation, and this is what I think. When I think of litigation, I always think torts because it's a big part of civil litigation. Otherwise, be well, folks.